evening time, so I thought more people could join from
Yeah.
wider network of historians and researchers. So I
Sure.
did send it out to some labor historians, gender historians, and the faculty of my own college. So some people should be joining from there as well.
Great.
We often, because single and multitask, we do put up our recordings, in fact, live stream all our webinars on our YouTube channel. So there'll be people who will be catching up, not necessarily on this platform, but on YouTube.
Yeah. Sure.
I think, Jessica, we're more or less touch our upper head. So I think we should begin and not get into.
Okay, ma'am, we'll start. We started with the streaming as well. So we'll just start. Good evening to one and all present here. I, on behalf of Women's Studies Center, Jesus and Mary College, would like to extend a warm welcome to you all. The Women's Studies Center launched the webinar series towards 75 years of freedom, contemplations, and reflections on the women's question in August 2021. The series marks a small effort to usher in 75 years of freedom with necessary dialogue on pervasive inequalities and gender dynamics from the time of the late colonial period into the post-independence era. We have had the honor of hosting noted scholars to speak on pertinent aspects of ongoing debate on women's lives and experiences over a long and tenuous period of changing circumstances. Professor Archana Prasad from JNU, Professor Charu Gupta from DU, Professor Samita Sen from Cambridge University, Professor Janki Nair from JNU are among some of our speakers at the webinar series. Today, 13th April, we are excited to host a noted academician in the field of feminist legal studies, Professor Prabha Kotiswaran, who will be speaking on the laws of social reproduction, bridging silos, theorizing resistance. Dr. Prabha Kotiswaran is Professor of Law and Social Justice at King's College, London. Her main areas of research include criminal law, transnational criminal law, sociology of law, post-colonial theory, and feminist legal theory. She has authored many books such as Dangerous Sex, Invisible Labor, Sex Work, and Law in India, which won the 2012 SLSA Hand Prize for Early Career Academics, and Revisiting the Law and Governance of Trafficking, Forced Labor, and Modern Slavery. Recently, she has co-edited a rock volume titled Governance Feminism, Notes from the Field. She is currently working on a project on the laws of social reproduction. Thank you for taking out time for us, Professor Kotiswaran. We hope that many more are going to be able to engage with your work through our YouTube channel, where we are live streaming all webinars of this webinar series. Over to you, Professor.
Thank you, Jessica, for that very kind introduction, and thank you to all of you for joining in. Given the occasion, which is, to mark the 75th anniversary of Indian freedom, I want to ask today what freedom has meant for Indian women as workers engaged in social reproduction. So I want to share my research today from a project called the Laws of Social Reproduction. And here I'll make an attempt to offer thoughts on how to bridge the silos that have emerged between women workers, and to argue why bridging these silos is crucial for theorizing resistance. So my talk will be distributed across 3 parts today. I will first start with an overview of what social reproduction is and how feminists theorize it. The second part will discuss the importance of bridging silos of women's work. And the third part will focus on the centrality of law in recognizing women's reproductive labor and the opportunities that it offers for resistance. I want this very much to be an interactive session. So I would welcome you to please raise your hands if you have any questions or clarifications. So at the end of each part, I will invite you to pose any quick questions that you have on what I've said, so that we can then carry on our conversation. So I really look forward to engaging with you all. So to begin with, what is social reproduction? And so here, if we could have the first slide, please, that would be great. So I think, as you can see, this is a definition which is presented by Shireen Rai and Carolyn Hoskins on what social reproduction is, and this is what I use for my work. So by social reproduction, they mean it includes biological reproduction, unpaid production in the home, social provisioning, reproduction of culture and ideology, and provision of sexual, emotional, and affective services. In very simple terms, social reproduction is work that makes our lives possible. All of us who are here today have drawn on reproductive labor of various kinds to make this interaction possible. So, of course, social reproduction has been an area that feminists have theorized on for decades now. In particular, they have theorized, women's unpaid domestic and care work for decades. So we find Marxist, socialist, and autonomous feminists have debated domestic labor and wages for housework in the 1970s. We find the Wages for Housework campaign taking root in the UK and Italy and then spreading to the US. Of course, we can also, the theorization of social reproduction, took shape well before the 70s, but I just happened to start with the 70s and the Wages for Housework campaign. We find feminists like Maria Rosa Della Costa, Selma James, and Silvia Federici, who are the key proponents of the Wages for Housework campaign, highlighting the role of women's unwaged labor in the home and its connection to the production of surplus value under capitalism. So we find that some of these activists claimed that the demand for wages for housework was a political perspective and a revolutionary strategy more than a demand for salaries for homemakers. As Silvia Federici has clarified on several occasions, these feminists wanted to put a price on the value of housework, only then to reject it. Whereas other activists viewed wages for housework not only as a demand of the state for payment to homemakers, but also as a political perspective which redefined the working class internationally as including the unwaged and the low-waged, men as well as women, as well as those in the home and on the land. So right from the beginning, we see that there was an ecological component to their thinking on social reproduction. So over time, of course, the Wages for Housework campaign has pushed the debates on social reproduction towards demands for the right to land ownership, for decent and affordable housing, leisure time, accessible childcare centers, and related infrastructure services, which are likely to reduce time spent on housework. And we find that in 2000, the International Wages for Housework campaign called for a global women's strike, which demanded, amongst other things, payment for all kinds of caring work, whether it is work within the household or whether it's caring for the environment and the community around us. We also find that as part of the Green New Deal for Europe, there is a policy recommendation to fund a care income to compensate various kinds of unpaid activities. But of course, there are other sort of interpretations of wages for housework in this contemporary context. And we find feminists like Kathy Weeks, who has argued that actually the demand for universal basic income would best capture the insights of the Wages for Housework campaign in our contemporary context. So, of course, Wages for Housework was a campaign that theorized women's unpaid domestic and care work in the 70s, but it did not actually take off as a mainstream political campaign, although it continues to be highly relevant to how we think about women's reproductive labor. What we find instead is feminists crafting a vocabulary of reproductive labor to chronicle the international sexual division of labor. So we find literature on global care chains as globalization takes shape in the 1990s. We find feminists studying various forms of reproductive labor outside the household as well. So this is including in sex work, in surrogacy, in egg donation, in paid domestic work, in nursing and teaching. And they've deconstructed several of the binaries that prevented the recognition of the value of reproductive labor within the Marxist and materialist canon. So I won't go into too much detail here, except to say that the frontiers of studies of social reproduction were furthered when you look at reproductive labor also performed in other institutional settings outside the household. So this includes childcare centers, schools, hospitals, nursing homes, care homes for the elderly, and so on. Now, in addition to materialist feminists, we find post-structural feminists also interested in this study of reproductive labor, but of course they use the vocabulary of life's work instead. And they have paid attention to the interaction between non-humans and processes of social reproduction, for instance. They focus not only on capitalist economies, but also on diverse economies, including non-capitalist economies and para-capitalist economies. And so studies of social reproduction for them are not limited to women alone. They also study the role of men. And the possibilities for political action as we sort of enhance the frontiers of the study of social reproduction, the possibilities for political action have also expanded. So we find, feminists understanding broader political struggles around housing, healthcare, food security, climate change, for instance, and pensions even as being fundamentally about social reproduction. So for instance, recently members of the CARE Collective in the UK co-authored the CARE Manifesto, where they used the lens of care to envision a restructuring of the community, of the state, and of the market. And they shifted the focus away from care being merely a feminist issue, where care is thought to be performed within the household, predominantly by women, to recognizing that care is performed by various actors in society. Meanwhile, we also find that this theorization around social reproduction finding a foothold in international advocacy campaigns. So for example, feminist economists have been successful in translating this feminist thinking around care and social reproduction into the Sustainable Development Goals, for instance. So we find SDG 5.4, which talks about unpaid care and domestic work, and the need for it to be recognized, reduced, and redistributed through a range of state policies. Now, of course, we know that since the pandemic, these insights of feminist thinking, which were often at the margins, have now occupied the policy mainstream. So we find that these materialist feminist classics on social reproduction have a new resonance as women have continued to perform a much higher amount of unpaid work during the pandemic and have also lost jobs in the informal as well as in the formal sector. And some argue that this has brought down female labor force participation rates to what it was in the 1980s. So the need to build a robust care infrastructure has registered with political leaders, even in a powerful economy like the US, which signals a sharp shift in how we think about care work. Now, how much of this moment of crisis will translate into long-term change is something that is yet to be seen, but the pandemic has certainly highlighted the centrality of social reproduction to the economy in different contexts. So I'll just pause there for a minute because this is something that I just wanted to use as a context against which I want to now speak about the laws of social reproduction. So if there are any questions or clarifications at this point, I would welcome them.
Do we have any clarifications at this stage, or should we move on? I think the overview is pretty clear, Prabha. So
wonderful.
We can move on.
Yeah. Sounds good. Thank you. Okay, so could I please have the next slide, Jessica? So what I now want to do is say a little bit about the project that I'm currently engaged in. So what I'm trying to do is try to theorize social reproduction through the lens of the law. And in order to do this, I draw on various literatures, but specifically critical legal scholarship and social legal scholarship. And here I try to study social reproduction through a sectoral lens as well. So in particular, I'm looking at 5 sectors of women's work in India. And I map them along a marriage market continuum. Of course, there are many different ways of theorizing it, and this is just one that I found useful for my study. So I'm looking in particular at how the law regulates sex work, erotic dancing, surrogacy, paid domestic work, and unpaid domestic work. And the idea here is to dissolve some of the silos that we've become accustomed to when we think about these various forms of women's work, And the key claim here is that if you look at the empirical realities of work in these various sectors, the social realities are not so distinct from each other for us to warrant a different view of, say, sex work from unpaid domestic work. So as we know, usually sex work is something that is sought to be viewed as violence against women. And there's a very extensive debate around how feminists theorize sex work. But my argument, just to put it on the table here, is to say that there are enough similarities between these different forms of labor that we shouldn't necessarily treat sex work purely as violence. Of course, there is violence within sex work, and nor should we treat unpaid domestic and care work as being on a pedestal and as being different from sex work or commercial surrogacy. And certainly for purposes of the law, the idea is to ensure that we don't treat these different regimes as so entirely different that you use the criminal law to ban sex work, but you allow family law to regulate unpaid work. Instead, what I'm trying to do is to actually argue that the law has its own logic when it comes to regulating these different forms of labor, and that we shouldn't take it for granted, and that we should actually think of the law as being highly contingent in the way that it views these various forms of labor. And the reason for this is, as I said earlier, that actually there are a lot of similarities between these various forms of labor. So I'll just give you a few examples which I think help us understand why we need to bridge these silos and why we need to actually theorize resistance in a different way. So for example, when we think about these various forms of reproductive labor, the first thing that often comes across is that it's actually very hard to estimate how many women are performing any form of labor which I've set out here. It's very hard to actually estimate the precise size of any of these sectors. So when it comes to sex work, you'll find very wide-ranging numbers, say from 1 million sex workers to 10 million sex workers. Similarly, with surrogates, I think there isn't even really an estimate of how many women might undertake surrogacy. Similarly, you'll find quite a wide range of numbers when it comes to paid domestic work. And certainly with unpaid domestic work, it can be anywhere from 160 million women to 300 million women. And this has some very serious consequences in terms of advocacy, because we are actually never really sure what are the numbers of women that we are trying to write about or study, and how this might translate into regulation or a demand for laws that can actually further economic justice for women. Similarly, we find that often women in these various sectors come from similar socioeconomic backgrounds. So of course, unpaid domestic work is an outlier here, but we find that a lot of these women work in highly gendered sectors and highly informalized circumstances. We often find that there is a high level of mobility between these sectors. We find that there is a deep interconnectedness with the institution of marriage. So you'll often find, say a surrogate may be a homemaker, but then she becomes a surrogate for a certain period of time. You might find that a sex worker is married earlier, and then she becomes a sex worker, and then she exits sex work to go back into marriage. So there's a lot of interconnectedness both between the sectors and between the institution of marriage. Often you find that a lot of women, especially at the market end of the spectrum, earn a lot more than you might expect for their educational and skill levels. Similarly, they suffer from high levels of stigma. And you find that also there are very different dynamics that inform how these forms of labor are understood. So for example, in the context of commercial surrogacy, many ethnographers have told us, have studied this in great depth, and tell us very beautifully how the commercial surrogacy sector is informed overwhelmingly by a logic of altruism. So fertility clinics, commissioning parents will all talk about how surrogates are performing this incredibly powerful altruistic form of labor. But the reality is that being highly altruistic and for surrogates to imbibe this altruistic subjectivity means that they are then not able to demand their rights as workers when performing this form of reproductive labor. Conversely, if they are if they are demanding rights as workers, often they are punished by actors within the sector because they're not good enough mothers, because they're not focused on being altruistic but simply want to get paid, so they're portrayed as being greedy. So there are these logics that operate within each sector which actually undermine women's bargaining power. And one of the other sort of key characteristics of the work that women do is also boundary work. So often women in any sector will present themselves as being superior to women in another sector. So surrogates will argue that they're superior to sex workers, or dancers will say we are superior to sex workers. So there is often very careful boundary work that women perform when they do this various kinds of work. And we find that there's a lot of heterogeneity within these labor markets. And so it's not always clear that if you're trying to argue to protect the rights of a certain group of women workers, that all women within that sector will actually benefit. So it's very important to understand that these groups are very heterogeneous, and therefore that there is a severe collective action problem in terms of women workers coming together. So what I've tried to I've just highlighted a few similarities between these various forms of work. And the law similarly structures these forms of work by reflecting often the social understanding of these forms of labor. And the argument that I want to make is that actually the law plays a very important role in organizing women's labor in these various sectors, and that we should understand the law's role as contingent, and that we need to bridge the silos between women working in these various sectors if we want to actually come together to theorize resistance. So I think I will pause here again to see if you have any questions or clarifications at this point.
Anything, students, that you want the speaker to elaborate further, or because the internet issues, you missed a point?
Ma'am, I just had like a small doubt. How is erotic dancing, linked to licensing law? I mean, that's something pretty new to me itself.
That's a very good question. Yeah, actually, it is a paradox that I think we lawyers need to understand a bit better. So actually, you're right. Dancing is usually, so if you think of erotic dancing, there are many, many different forms. But the one that we are most familiar with, which has been the subject of litigation, is bar dancing in the context of Maharashtra. And there, of course, the law that actually, on the face of it, the law that governs dancing is the Police Act, the Bombay Police Act. But, and this is the paradox that we need to unearth, which is why is it that the police have the power to license these businesses? So it's effectively a criminal law that regulates erotic dancing. But if you look at it on a factual basis, it gives the police the power to license these businesses, which is why I bring it under the ambit of licensing law. So although on the face of it, it's a criminal law, in effect, what the police does is to issue licenses and to impose a whole range of conditions. So so erotic dancing is permissible under certain conditions. And in that sense, sex work is also a form of, selling sexual services, again, is legal per se under the Immoral Traffic Prevention Act. But pretty much everything related to performing sex work is illegal. So it's further along the line of being criminalized, whereas with dancing, the effect may be, or the effect has been, that although it is licensed, subject to licensing law in Maharashtra, the conditions are so stringent that effectively you shut down an entire form of labor by imposing very stringent conditions on it. So that's why I refer to it in terms of licensing law.
Ma'am, Ms. Shehel has a question.
Hello, good afternoon, ma'am. So my question essentially is, what does the legal text entail regards to erotic dancing? What makes it a criminal activity, so to say?
So it's not criminal per se. So this is very interesting. So actually, let me illustrate it with the example of the Maharashtra bar dancing litigation. So as you all know, when the Maharashtra government tried to ban bar dancing in 2005, this was challenged by an association of hotel and restaurant owners. So it went to the Bombay High Court. And the Bombay High Court effectively said that the government could not clamp down on women's right to livelihood. And they upheld the right of bar dancers to, perform erotic dancing. But what they said at that point very clearly was that dancing was something that had been part of Indian culture for a very long time. And so per se, it is a legal activity. So they use the term that it is res commercium, meaning that it is a legal activity. It can be the subject of commerce. And they contrasted that to sex work, which they said was res extra commercium, which is that it is an illegal activity. And, that's how the court read it, although it's not strictly speaking right. They distinguished between these two forms of women's work. And they said that, sex work per se is illegal, whereas bar dancing per se is not illegal. So the point at which bar dancing actually becomes illegal is when it becomes obscene. So it becomes illegal when you violate any of the conditions in the license. So effectively the police will grant a license to a bar and they'll say, well, women have to be, X distance from the customers. You can't shower money on them. You have to have CCTVs. So, these were the kinds of conditions. So let me just spin out a little bit what happened with that bar dancing litigation. Once the Bombay High Court said that this prohibited their right to livelihood and struck that law down, it went up on appeal to the Supreme Court, which again upheld what the Bombay High Court said. But of course, then the Maharashtra government came up with a new law which made it very difficult to carry out any kind of bar dancing. And that was again challenged before the Bombay High Court and then the Supreme Court. So eventually, I think it was in 2019, the Supreme Court said, well, some of the conditions imposed by the Maharashtra law are valid and some are not. So they said, if you have a CCTV camera in the bar, that should not be allowed because it violates the right to privacy. But if you have some requirements around what distance should be maintained between the customer and the dancer, that is perfectly legitimate. So it's a very mixed kind of judgment that the Supreme Court handed down. But what would make bar dancing under those circumstances illegal would be violating any of those conditions on the basis of which the license was issued to the bar. And of course, if it's obscene. But the whole idea of imposing these conditions is to make sure that it doesn't become obscene, or that's what the government thinks, that if you impose all these conditions, then there's less of a chance for the dance to become obscene. If you don't serve liquor, for instance, along at the same place that the dancing is going on. So effectively, in trying to make sure that the dancing is not obscene, it actually makes it impossible for the business to carry on, which is why the Supreme Court decision is very mixed. It has mixed ramifications for women's right to livelihood. Did that answer your question?
Yes, ma'am. Thank you so much.
Sure.
Prabha, I had a quick clarification, which I think that the students would also benefit from.
Sure.
Similarly, like when you've looked at paid domestic work, and you have connected it to the realm of contract law. So I was just wondering, because as a center, we've often had sessions, 2 or 3 at least, where we've discussed about how this one segment of the workforce which is left out of labor law, and of course also contract law, because of most of the work is an unwritten form of agreement between a domestic worker and a madam. So how are you seeing the link with contract law and domestic?
That's very important. That's a very important question. So actually, so what I've put out here is that these are the default legal regimes. So of course, I'm aware that several domestic workers groups, unions, and activists and academics have argued for a very long time that there should be a sector-specific law for paid domestic work. And I completely, wholeheartedly agree with that. I guess what I was trying to simply say was that the default regime is of contract law. By that I mean that although a contract doesn't have to be written for it to actually be valid. So you could have a verbal contract, you could have an implied contract, even if you don't have, a contract that specifies working conditions, you still have the whatever you've agreed upon with the domestic worker, that's still a contract. So the default is the way I think of it is that there is a contract between, typically there is a contract, even if it's a verbal contract, even if it's an implied contract between an employer and a domestic worker. Of course, it is violated all the time, right? And the conditions, the terms of the contract keep shifting. But even if you had three terms, the amount of pay, the number of days, that's still a contract. And what is very interesting is that I'm aware that a lot of activists, would like sector-specific labor law. But if you actually look at some of the case law around domestic workers, or at least some of the case law that I've looked at, I found that often the context in which paid domestic work comes up before the courts is not in the context of contract law. You'll be surprised to find that a lot of the cases deal with criminal law, surprisingly. In fact, it's domestic workers who have often been sexually abused or harassed by their employers, typically by the male men in the household. And it will often come up to the courts as a case where the domestic worker has turned hostile, so the rape prosecution doesn't go ahead. So if you look at the lived legal realities of paid domestic work, you could also question whether it's governed by contract law. It seems like criminal law is what is invoked most often. So I think what is interesting is that there is an interplay of these various legal regimes when you consider, forms of work, which is why I said that, these are contingent understandings of how the law regulates, women's labor. So you have to understand the relationship between contract law and criminal law, especially because although we have the sexual harassment law, which applies to domestic workers, we don't have the infrastructure that is in place to actually protect their rights. And of course, there's a series of inclusions and exclusions in the new labor codes when it comes to paid domestic work. So it's a very fragmented sort of legal landscape when you look at paid domestic work. Is that useful?
Yes, it is. Thank you.
Great. Any other questions? Okay, wonderful. So what I want to do is, and I think that's your questions have made me think that actually I'll say a little bit more, because I wasn't sure this is not a legal audience, or an audience well versed in the law. But I think your questions made me think that you would appreciate some further clarifications on this question. So, for example, if you look at sex work, we often think of the Immoral Traffic Prevention Act as being the key law that governs sex work, right? As I said earlier, running a brothel is a crime, living off the earnings of sex work is a crime, soliciting in public is a crime. So there are many aspects of, sex work which are criminalized under the Immoral Traffic Prevention Act. And that generates a whole range of perverse consequences for sex workers. As we know, even if the ITPA is not enforced all the time, and we know it is not enforced all the time, because there are red light areas in many big cities. We find that, sex workers do perform sex work in particular neighborhoods. So clearly the state is not enforcing the ITPA all the time, but it uses it selectively, and which is what undermines women's bargaining power, because you just don't know when the police will use the ITPA to essentially arrest you. And then you have to spend the night in the police lockup. And the next day you have a summary trial, you end up paying a fine of 1,500 rupees. And then you have to go back and earn that money, which you've lost because of the state's imposition of a fine on your form of livelihood, or at least the way sex workers perceive their work. So much of the debate around, what should we do to enhance women's, sex workers' economic justice is focused on the Immoral Traffic Prevention Act. And of course, the new trafficking law and the trafficking-related provisions of the IPC. But often we find that there are other sets of rules that are equally important. And so I just want to say, for example, in many red light areas in Indian cities, what is equally important is the property relations that sex workers enter into. So often in red light areas, for sex workers, where they work and where they have a family, their residence and their place of work is the same, is one and the same. So often the rooms that they live in both qualify as a brothel, but it's also their home, right? It's the space of their home. And we find that the kind of property relations that they enter into, either with the landlord or the agent of the landlord, can affect their bargaining power, within the red light area. So some of the work that I've done previously on this relates to the role of, say, rent control laws. And you find that if sex workers actually have, different sets of sex workers will either benefit from the rent control laws. The older sex workers will benefit from it because, when they leave the red light area, they'll receive a large premium for leaving that property. Whereas the younger sex workers are saving money in order to be able to buy a property by paying a premium under the rent control laws. So, it's so I just want, the minor point here is really that we should always be aware, and this is what lawyers, social legal scholars do, which is to map at all times the range of laws that affect social actors. And it's particularly important for women workers because it's not always one set of laws that we are always focused on. We also need to understand that other than criminal law, it might be that, contract law affects sex workers or that property law affects sex workers. So we have to always remember that there are different sets of laws that can actually determine women's economic bargaining power. So, and now, for example, with surrogacy, although I put down contract law there as the default, and it was the default for a very long time when commercial surrogacy was legal, but it's no longer legal. So in fact, now we've defaulted to a different set of rules. And there are some stringent punishments under the Surrogacy Act and the Assisted Reproductive Technologies Act, which would make, selling reproductive labor or bearing a baby for money would be a crime. So we need to always understand the interrelationship between these different sets of legal rules. So that's the second part of my talk. And now I will go to the third part, which is to say that, as I've shown already, if you look at the sectors on the left-hand side of the slide relating to, market-based commodified forms of labor, these are often banned by the state. And you find that the government is quite indifferent to the rights of paid domestic workers. And how does it then deal with unpaid domestic workers or homemakers? So here I want to share with you, and many of you may be already aware of a positive legal development in recognizing women's labor. And here I want to share with you some of the cases that I've studied under the Motor Vehicles Act of 1988. And I want to show the conditions under which the law's recognition of women's labor is possible and what the strengths and drawbacks of that kind of recognition might be. So what I want to share with you here, so if you could please go to the next slide, Jessica. Yeah. So, we find that there's the number of road traffic accidents in India is very, very high. It's about 150,000 people a year die from motor vehicles accidents. And so often when someone dies because of a motor vehicles accident, their dependents will go to court under tort law. It's a regime of private law, and they'll say, well, they need compensation for that person's demise, because if that person had continued to live, they would have earned a salary over a very long period of time. Then there are expenses related to their death, funeral expenses or medical expenses. So under various categories, the dependents of that person who's died will go to the courts and claim compensation, typically which is paid by an insurance company. So we find that there are two categories of damages, as we call it, under tort law, and I'll keep it very simple. So it's just to the extent that it's important for me to communicate, how it recognizes women's work. So in very simple terms, there are two kinds of losses. One is an economic loss. So the example of loss of income, right? Someone working in the formal sector, they have a salary certificate, and when they die, you can say, here is the salary. Let's multiply that for the year, and let's multiply that for their their lifespan, say 25, 30 years, depending on the age of the person who died. And we come up with a large lump sum. And then you add, say, medical expenses, funeral expenses, loss of estate, all of that, and you award a large amount, right? The second kind of loss is non-pecuniary or non-economic losses. So these are intangible. It's very hard to put a price on them, like pain and suffering, loss of love and affection, loss of consortium. So what I want to share here is that there's a whole range of cases that have come up to the Indian courts where homemakers were killed in accidents. So the husband of the woman and her children would come to court and ask for compensation. So obviously these women often were not working outside the home. And therefore, the courts were faced with the predicament of trying to decide how should we value, the labor of these women? How should we compensate their dependents? Because the dependents are suffering from the lack of the services that women would have provided to them had they been alive. So what we find here is that courts struggle to arrive at a figure. So one of the earliest cases dealing with a homemaker came up in 1968 before the Bombay High Court. And here the court said, well, the husband was entitled to compensation, which would have represented the value of the services had he bought it on the market. So if he had to engage, the court used the word servant, what would be the cost? And we will award that cost to the husband. So in the initial decades, when these kinds of cases came up to the courts said, we will award what are called replacement costs. How much would it cost to replace the services of the woman who's died? Now, what happens in 1988, and if we can just go to the next slide, please. What happens is, the court, in this case, it's the Andhra Pradesh High Court that uses common law. It goes to an English case, which talks about how it's not enough to just, think of services in a narrow fashion, which is, the replacement value of a housekeeper. That's not enough. That's what the English court said. They said this is because actually a woman often has to work 24/7, especially if she's a mother. And there's all kinds of labor that she performs. So you can't construe services very narrowly. So if we go to the next slide, what we find here is the Andhra Pradesh High Court says, well, Indian mothers are not very different from English mothers. So we actually should not construe their services narrowly. We need to think of it in a wider manner. So they said this, which of course you can see what they've said, the Andhra Pradesh High Court. But here is the important point. So the English court awarded compensation in that particular case for what they said was loss of gratuitous services. And this was a fixed amount. Even today in England, if such a case came up, you would award a maximum of say £5,000 under loss of gratuitous services. So if a husband passed away, maybe he used to tend to the garden, he would do work around the house. So you just kind of say the family has lost his services, we will just give you a fixed amount. So this is what the English courts said. But what the Indian courts did was they took this idea of gratuitous services and they expanded it. So this would have been a non-economic loss. But the brilliance of the Indian courts was to convert this into an economic loss. And they said, well, actually, because homemakers are doing much more than just, domestic work, they're also doing all this care work, we won't give you a fixed amount. We will instead treat it as an occupation. So we will instead treat what the homemaker does as an occupation. So we will arrive at a monthly amount, we will multiply it for the year, and we'll multiply it for the rest of her life. So where earlier under common law, all you could get was a fixed amount, say for loss of consortium, loss of love and affection, loss of services, what the court effectively did was to put homemakers on par with, homemakers having an occupational status. So this is a very major innovation on the part of the Indian courts. And this was then developed in 2009 by the Madras High Court, where Justice Prabha Devan adopted an explicitly feminist take on this understanding of the unpaid work of a homemaker. And she cited to, CEDAW, to international law, and she said that actually, a homemaker does a lot of work in the home, and she offers like a middle-class understanding of her social reproduction, which is managing budgets, coordinating activities, nursing care, managing help at home, helping children with education. And there she said, we must compensate the woman for this kind of work. And not only should we compensate women when they've died, but we should also incorporate this into family law so that when there is a case of divorce, a woman is compensated for the unpaid work that she's performed in a marriage for a long period of time. Okay. So this was a Madras High Court decision, and then it went up to the Supreme Court in 2010. And I think I have a slide, but can we just go to the next slide, please? Yeah. So this was the case of Arun Kumar Agarwal, and many of you would have heard of this. So in 2010, this case came up where the Supreme Court basically confirmed what the Madras High Court said and observed that, and this is a beautiful judgment. I would encourage all of you to read it. It's not very long, but you find here that actually Justice Ashok Ganguly draws on a whole range of feminist scholarship, including that of feminist economists, where he talks about how we need to have a broader understanding of women's unpaid work. We can't list homemakers alongside beggars, prisoners, and sex workers in the census. We should have an expansive understanding of work. We need to count the unpaid work that women are doing. We need to make sure that we have time use surveys to assess the unpaid work that women do. We should also reform family laws so that we recognize the unpaid work of homemakers. So I realize that I probably don't have a lot of time, so I will now go quite quickly. So this was a milestone decision of the Supreme Court, which has been most recently confirmed in 2021 by the current Chief Justice, Justice Ramana. But what I want to say very quickly is that once the Supreme Court affirmed the recognition of women's unpaid work, a whole range of high courts followed suit. So you find that some high courts glorified the unpaid work that women performed by simply saying women are upholding the cultural fabric of Indian society, they are nation builders. It uncritically glorified women's work. And then there was another set of judgments that were thought about marriage in a more equitable fashion. They said, well, the work that a woman does at home is as important as the work that a husband does outside, in paid employment. And that in fact, sometimes the work that the woman does is even more valuable than what the man does outside the household, and had a more sort of companionate understanding of marriage. So you find both kinds of judgments come from various high courts. But what you also find is that when courts have to decide how to compensate these dependents or these homemakers who were killed, there were various factors they considered, some of which were problematic. So in one case, a newly married housewife was killed along with her husband. And there the parents of the woman had filed a case before the tribunal, and the tribunal awarded compensation to her parents. But then her in-laws appealed against that decision. And then actually, I think this was the Haryana High Court or the Punjab and Haryana High Court, essentially said that it's the in-laws who should be compensated because in effect, she had moved to their family and they were entitled to her reproductive labor throughout her lifespan. So they should be getting that compensation. This is a very interesting case. And they said, well, in the North, we are more patriarchal. Maybe in the South, it would be a different kind of decision-making process, but not in Northern India. Similarly, you find that, courts would award compensation based on whether a woman had children or not, depending on the age of the children, depending on whether the children were, had any kind of, were specially abled or not. The courts also would award higher compensation until a certain point. So they assumed that after the age of 55, that women would do a lot less unpaid work. So therefore the compensation should go down and that it should completely be over by the age of 60. So there is an assumption that women don't perform any reproductive labor after a certain point, which as we all know, is not necessarily the case. In some instances also, if you were of an upper class, you got more compensation because the court assumed that if you went out, if you were educated and you went out to work, you essentially the opportunity cost of your going out to work, of your staying at home was high. So in fact, your compensation should be higher. So if you're of an upper class, if you're an upper class woman, your dependents got more compensation. So I just want to say that, so the law is a very key site for recognizing women's unpaid work. And there are many strengths to this recognition, but that there can be also quite important drawbacks that, as we know, we need to be cognizant of. But what I want to say, and I want to end on this slide, actually, if we can just go a bit ahead, Jessica, not this one, the next one. Yeah, so the next one. So I just want to end here by saying that in 2021, the Supreme Court said very categorically that actually the fixing of a notional income of a homemaker attains special significance. Justice Ramana said that this becomes a recognition of the work, labor, and sacrifices of homemakers and a reflection of changing attitudes, and that it is in furtherance of our nation's international obligations and our constitutional vision of social equality and ensuring dignity to all. So this is a very key judgment which talks about recognizing, the reproductive labor of homemakers, and I think this is what holds potential for ensuring, economic freedom and independence for Indian women going forward. So I think I'll stop right there.
Ma'am, should I stop presenting?
Yes, please. Yeah. Thank you.
So we're opening the floor to
this question. When the Indian courts in matters of motor accident cases have worked with the concept of the dependent position of women in marriage relations and hence the compensation angle, how do you explain their court's aversion to extending this principle of dependence to recognize factor in sexual exploitation within marriage in terms of marital rape?
The questions in the chat box as well, Prabha.
Oh, I see. Oops. Okay, I haven't actually kept an eye on them. Sorry. Okay. I think that's a really, really important question. Could you say a little bit more about it? I mean, I have a complicated position on this, and obviously it's a very complicated question to begin with, and I don't see any reason to have an immunity for marital rape under the IPC. So I want to be very, very clear about that. I don't think there should be any kind of immunity for husbands. I mean, that said, I think for feminists, it's a slightly more complicated question because obviously we know that marriage is a site of economic dependence for a lot of women. So I think criminalizing husbands, so it is a rape, marital rape is rape, no question about it. I think in this kind of audience, I think it's well worth our consideration to think about, both the intended consequences and the unintended consequences of criminalizing marital rape and what that does to women who don't have any other source of livelihood or income and may have young children who are dependent on them, right? And I think we also have to look at the complex interplay between criminal law and family law, because depending on the level of sexual abuse within marriage, there's obviously grounds for divorce as well. And if you launch prosecutions under criminal law for rape as well as domestic violence, as well as you go under the Domestic Violence Act, as well as you go under the family laws for remedy of divorce, you have to see that what impact could a criminal case have on the family law proceedings. So for example, if the prosecution for marital rape fails, right, and the husband is acquitted, it could strengthen his bargaining power in a family court because he's saying, well, sexual abuse has not been proved, right? So I think we need to be very careful about what the consequences of criminalizing marital rape are in that sense. But I mean, how do you explain the court's aversion? It's actually a really because I think it goes to the heart of the institution of marriage, and I think and it would be interesting. So I think the right way to pose that question might be to say, if a woman in a divorce proceeding said that she wants compensation for her unpaid domestic and care work, right? Or a share of the matrimonial property, I have a feeling that you would have similar responses from the courts. So you see what I mean? I think it's easier to maybe compensate the unpaid work of a woman after she has died in an instance where the insurance company is actually paying the dependents of her paying her dependents, rather than if you were to bring it up in a family law case, whether in the context of marital rape or divorce. So I think that would be the true test to see why the courts are so averse to challenging the institution of marriage, which I think feminists cannot lose sight of. We have to absolutely challenge it on every front, whether it's family law or criminal law.
Members, we are open to more questions. If there are any questions, you can either unmute yourselves or put them in the chat box. We'll take them out. Ma'am, there's a question in the chat box, and yes. Michelle has also raised her hand.
Why don't you let Michelle go first?
Michelle, you can go ahead.
Yes. Hello, ma'am. So my question is basically, it's similar to the last question I asked, but why per se is commercial surrogacy criminalized, or is it considered a criminal activity? Because like you mentioned before, it is a means to earn a livelihood. And I do not remember the specific documentary, but it is available on YouTube, where they studied a community of people who were essentially surrogate mothers, and they were all living together and they cooked for themselves, etc. So there was a market that was available, for the lack of a better word, and they sustained themselves. So why is it criminal?
Yeah, well, as you know, I think the decision to okay, so how do I go back to, so the question is, how far back do we want to go in order to answer that question, right? If I had another half an hour, I'd go through, the laws from 2005. But let me just say this, that in 2005, the Indian Council for Medical Research had regulations on surrogacy and ART, and had a very liberal, a medico-liberal approach, I call it, towards surrogacy, where you could have compensated surrogacy. And this, of course, led to, as we know, a very robust kind of transnational market in surrogacy with medical tourism, where, commissioning couples were coming from all over the world to India to actually, commission surrogacy, and for women to then be paid in order to, deliver the babies. And if so this has been extensively documented by ethnographers in pretty much every city in India. There are books now that talk about what happened during that phase. And as we know, I think the medical establishment itself had a very liberal approach. By liberal, I'm not saying it's positive, but liberal, I mean in the sense of permissive approach to, commercial surrogacy. And the interests of surrogates were not necessarily being protected at all. And we know in terms of the number of embryo transfers, in terms of the fetal reductions, in terms of miscarriages, in terms of C-sections. I mean, there were many instances of, I guess, reproductive violence against, these women, which were probably not fully documented at all. But by the time, the central government began to think about how to regulate surrogacy, especially because of its transnational avatar, they tried to limit who could access surrogacy. So to begin with, they prohibited all the LGBT couples from, accessing it. Then they said, well, you could be a PIO or OCI, you can access, surrogacy, but then they shut down that window as well. And then eventually they said we shouldn't be commercializing surrogacy at all. We should only allow altruistic surrogacy. So what really made the government then change its position completely from 2005 was a 2015 PIL that was filed, where the government, without any explanation, came to the court and said, from tomorrow, we are going to stop, transnational surrogacy. So they issued an order through the ICMR. So all clinics were told they cannot allow any more commercial surrogacy from foreign couples. And then, of course, set about, drafting this law. And ostensibly, it was to prevent the exploitation of women, right? But the problem in this instance was that surrogates were not really organized well enough. So there were associations of surrogates, but they were assisted or they were fostered by the fertility clinics. So they didn't really have a voice of their own. But what you're talking about is quite, has been documented by Sharmila Rudrappa, where she talks about surrogates in Bangalore actually wanting to set up their own cooperatives in deciding on what terms they wanted to alienate their reproductive labor. So I think there is room for surrogates to decide the terms on which they will do this kind of work, but it's a kind of moral panic around surrogacy that has led to its prohibition. And the idea being that, this reproductive labor should now be performed on an altruistic basis within the family. So that was what was proposed in 2016. But once the government realized that this would be completely impractical, that condition has been taken away. So the surrogate doesn't have to be a close relative, but she can still perform altruistic surrogacy. So a third party can perform altruistic surrogacy. But the question really is, will this happen? And what it ends up doing is then on the face of it, producing an illegal market, right, which is not regulated, so that all the other stakeholders will actually benefit from those transactions. Everyone will benefit except the surrogates because you've made it illegal now. So I actually think that when you ban something, you're not actually eliminating the practice. What you're only doing is you're shifting the bargaining powers in a way that actually it's the women who lose control over their reproductive labor. So I'm inclined to agree with you on how, on the fact that, surrogates do have a say, should have a say in how to perform this kind of work. But unfortunately, for the time being, they cannot under the new law.
Thank you, ma'am.
Ma'am, there's a question in the chat box.
Yeah. So, the term modern slavery is not actually something that, although the title of my edited volume does refer to modern slavery, it's not really a term that I, subscribe to, because it is a term that has been invented by, it's not a term that is defined in international law. It's a term that's been produced by, philanthro-capitalist organizations in the global north, to basically characterize extreme forms of labor exploitation. So I would prefer to think of modern slavery in terms of, indigenous terms which have come up in the Indian context in terms of forced labor. For example, under Article 23 of the Constitution, which the Supreme Court has read to mean that if you're paid less than the minimum wage, it amounts to forced labor. So I'd rather use the term forced labor and would use the term trafficking, which has legal meaning in the Indian context under Section 370 of the Indian Penal Code. So, of course, there are, so if we are talking about extreme forms of exploitation, they are absolutely rampant in the Indian context in various labor markets. There's absolutely no question about it. But what I do have a problem with is the use of the criminal law in order to address questions of extreme exploitation. And the thrust towards using criminal law, right, is coming from the global north, because if you look at the origins of anti-trafficking law, it comes from the Palermo Protocol, which was formulated by Western countries in order to prevent labor migration into, it was a border control regime. And so anti-trafficking law really criminalizes trafficking. But it's when you look at what they offer, quote unquote, victims of trafficking, it's very little. So most of those who are trafficked into the Western countries, have a brief period of reflection before which they have to leave the country. They are repatriated. So it is a project of border control. So the question is, by the time it gets translated into the domestic laws of other countries, especially in the global south, I think it assumes a very different form. And unfortunately, due to large amounts of funding from the global north for anti-trafficking initiatives, in the Indian context as well, we are completely obsessed with a criminal law approach to capturing the evil traffickers and putting them behind bars. What this does is only shore up the police power of the state, and I'm completely against that. I think instead what we should do is go to the very rich jurisprudence under labor law that we have that the Supreme Court has come up with, which has now been extended to Narega, for instance. Repeatedly, the Supreme Court has said if you don't pay minimum wages for Narega works, it is forced labor. So I think we should be concerned about trafficking. There is a role for the criminal law, but we should also think about extreme exploitation, which is rampant in India. And we have to have a multi-pronged approach to dealing with these forms of labor exploitation in the Indian context. I don't know if that answers your question, but I'm happy to say more.
It does. It clarifies a lot, Prabha. Students, do you have any further queries or comments? I just wanted to share one thought, Prabha, because you have 2-3 occasions, including just now, you have referred to the fact that, there is, you very often see the state intervening in these spheres of work and, labor that's performed by women, be it the paid domestic industry, if I can just focus on that particular realm of work, where the state enters when it becomes actually a matter of law and order, and it's actually mostly through the criminal law framework. And this is an important point, and I thought that I'd say something and you could reflect upon it and say more if you wish to. That it's very important that the labor law is very often not used, and this is increasingly becoming a paradigm now of state intervention, that you criminalize labor, especially collective forms of labor, and now also individual labor. And that's how the state is negotiating. That's exactly where you see the state's presence in this domain of work and labor. It's through the criminal framework, and it's an irony because the labor law framework and other possible intervention is strategically it's an agenda. It's part of the game plan not to use those.
Absolutely. I completely agree with you. I couldn't agree more. And I think it's a very interesting kind of, in the name of consolidating labor law, we know what has happened in the name of consolidating labor law, while actually I think every parliamentary session has yet another criminal law that we have to contend with, and it comes in various forms. So it's a real, so I think that's a space that we have to theorize the relationship between criminal law and all these other legal domains, because it's not just particular statutes that are criminal law statutes. You also find infiltration of criminal law mechanisms in other areas. So, for example, even whether it's in the context of rape or corporate affairs or surrogacy or you name it, right? You will find that in some very innocuous places you find criminal provisions being inserted. And certainly so in the context of surrogacy, for example, medical professionals have been very perturbed by the fact that, they could be subject to high levels of imprisonment for, any crime committed under the Surrogacy Act. But what is also interesting is that the definition of the crimes are very broad. So the idea is that, it's so broad, so it's, criminal lawyers know that you can have a crime, but you have to define it. That's what the Constitution requires. But what we are finding is that lots of innocuous forms of behavior are, brought under the ambit of a crime. And so even lawyers are not really sure exactly what is criminalized, right? Which is quite dangerous. And I think the ultimate backstop for the criminal law is the constitutional law, is the Constitution, is to really push very hard to uphold the rights of individuals against this kind of overreach of the criminal law. So I think that will become more and more crucial in countering these forms of criminal law.
Students, anything further you would like to pitch in at this point?
Ma'am, I had a small doubt when you were talking about damages under tort law. So the damages that you get under tort law are unliquidated. So does that depend upon the economic or the non-economic loss do you have, or are they the same kind of damages that you get?
It depends on, it really varies a lot. So in the context, are you asking about homemakers in particular, or because there's a very wide range of, so in the case of homemakers, actually many different benchmarks have been used to compensate the dependents. So the Motor Vehicles Act is now of 1988 is no longer in force. But when it was in force, it had a Schedule 2, which basically said that if you have someone who doesn't have any form of employment, the compensation they would get per month would be 1/3 of what their spouse earns. So here was a patently discriminatory provision of the law that was on the books for a very long time, that actually the Supreme Court notes in 2010, but they can't take action on it because it wasn't a writ petition that came up before them, so they couldn't rule on its constitutionality. So the courts would sometimes look to Schedule 2, sometimes they would look to a completely unrelated case of Lata Vadhva, which was a case where, it was a Tata plant, where they were having some celebrations, I think, and there was a fire, and many women and children died, many people died, and Supreme Court justice was asked to determine what the damages was, and he came up with the figure of 3,000 rupees per month. So, so that was not a motor vehicles case, but sometimes the courts would take that amount and say, let's do 3,000 rupees per month and let's increase it, because that figure was arrived at in the early 1990s. So they said, let us use that. Sometimes they look to the minimum wage schedules, in a particular state. So actually, in this case of Key Theme 2021, the Supreme Court actually looks at the minimum wage tables and ironically views her work as unskilled work when they are trying to, come up with an amount. So it really, and sometimes it's the opportunity cost, as I said. So Justice Geeta Mittal of the Delhi High Court in several cases spoke about, what is the opportunity cost? So what would she have earned for her? So it's actually quite an incoherent body of law, which doesn't lend itself easily to any kind of theorization. So I hope that sort of answers your question. But at the end of the day, if you actually look at the amounts, they're not very high at all. That's fine. So here, I think it's more the conceptual value of the recognition that we have to take away. If you actually look at the figures, they're very, very low, even after you multiply it for the lifespan of the woman. They were really paltry amounts.
Yes, ma'am, I understand. Ma'am, there's one more question from Michelle.
Yeah, so this is slightly unrelated, I'm not sure. But one of the ways that a lot of sex workers or people who engage in sex work contest for legalization and decriminalization is the unionization of sex workers. Do you think that unionization in sex work specifically would be that effective for people who engage in it, in terms of granting them rights, increasing their wage, and making it more normalized?
Yeah, that's a great question, Michelle. Actually, so I think we have to separate out the claims for unionization. So if you look at the sex workers movement in India, right? It's a very, very strong movement, and actually we are at the vanguard when you compare it to other countries around the world. The fact that Indian sex workers have mobilized so robustly. So often, so here again, there's a slight difference. So within the sex workers movement, so the National Network for Sex Workers, for example, would limit itself to decriminalization as a demand, which is simply to say any special law that applies to us should be repealed. So the Immoral Traffic Prevention Act should be repealed, which assumes that all other laws would be applicable to sex workers just as they would apply to you and me, right? If we wanted to start any kind of business, there are, you go to the corporation, you need a license, we are all subject to the same laws. There shouldn't be any specific law that targets sex workers. So that's one demand. But if you look at the All India Network of Sex Workers, especially the Durbar Mahila Samanvaya Committee in Calcutta, which in the 90s, came closest to a large sex workers movement, right, wherein these huge annual conferences, you found thousands of sex workers who met in the stadium and fought for, sex workers' rights. They articulated their demands slightly differently. So they asked for labor rights. So not necessarily, so they've tried to be recognized as unions. So this again varies. How you get recognized as a trade union really varies according to state. So I think in West Bengal to date, I think the registrar of trade unions would ask the very simple question of, where is the constituency of employers? What does this make sense? Especially if sex work is illegal under the ITPA, how can we register you as a union? So that's always been an issue. But then there are sex workers groups that have achieved union status through, the NTUI, being part of a federation of trade unions. So there are different ways of getting trade union status. But the question that you're asking about is in terms of day-to-day work practices, what does unionization bring, right? And you might decide that actually it's not a lot. It's not a lot. It's not necessarily conducive to fixing a minimum wage for sex workers, for example, because this would vary quite considerably. How would you enforce it, against, the customers? And it's a kind of triangular set of relationships, right? You also often you have a brothel keeper. So the question is, the brothel keeper is the one who then has to assume conditions, maintain conditions as an employer. And unfortunately, this debate around the labor laws for sex workers has not made a lot of progress since the 1990s, where there were, in fact, legislative models that tried to envision, what would unionization actually mean. So one of the books that I edited, it's called A Reader on Sex Work, which is published by Women Unlimited. If you look at the appendix, it has these drafts of these laws, actually, that talk about, what would a unionized form of sex work look like. And unfortunately, what has happened is because of the push of the criminal law against sex workers, and especially the anti-trafficking laws, sex workers have had to fight very hard against these anti-trafficking laws, which are essentially trying to abolish sex work for all practical purposes. So the conversation, so what would sex workers today think about unionization would be an important question. And there's an urgent need to revisit it in conversation with sex workers. But it's not entirely clear what I'm skeptical, and in my first book, I've talked about how I'm skeptical about whether importing a labor law model into sex work would in fact benefit sex workers. I actually, and at the conclusion of that sort of analysis, I concluded that it would effectively segment the sex work industry into the regulated segment and the unregulated segment, and so therefore, this sector is so heterogeneous. Women are so divided. They can't actually. You'd find that it has some positive consequences to certain kinds of sex workers, but actually, it would undermine the interests of other sex workers. So it is something that needs to be put back on the table and discussed by sex workers organizations yet again. Does it answer your question?
Yes, ma'am.
Members, are there any questions, or we can conclude the event with the vote of thanks? Ma'am, should we conclude the session?
I think we should.
I would like to extend my heartfelt gratitude to Dr. Prabha Kotiswaran for enlightening us with the knowledge and taking out time from her schedule for us. I would also like to thank our convener, Dr. Maya John, and other WSC staff advisors for the support always. Last but not the least, thank you all for joining us.
Thank you so much.
Thanks again, Prabha. It was a very, very useful session. And you kept it very interactive. So that's why we enjoyed it much more. And thank you to the team that live streamed. So this will be available as an online resource, Prabha. I'll also share the link with you. So, if you have circles of students, if you want to circulate it